order. Please stand and salute the nation's flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. In attendance this evening are Supervisors Fisher, Aguizio, Fleer, Cassiola, and Sababic. In addition, the Township Engineer Dan Deiseroff, Attorney Gretchen Moore, and Carol Perkis. Before I begin, I'd like to announce that we held an executive session on August 9th at 5 p.m. for legal advice for settlement negotiations on pending litigation related to the Bernard Schultz appeal. Moving on to 147-2021. Consider appealing the ruling of the Court of Common Pleas in the land use appeal filed by Jeffrey Omtick at 349 Grange Road, McDonald, PA, and any other matters that come before the board. This item was tabled at the Monday, August 3rd, 2021 monthly meeting of the Cecil Township Board of Supervisors. This special meeting was duly advertised on August 9th, 2021. I'll let the board comment and then I'll open it up for public comment. Please make sure you're speaking into your microphone because we are trying to live stream.
Yeah, I know was interested in tabling this to look further into it, and I couldn't find any reason to look at this and not set precedent. And I agree with what the solicitor says about it setting precedent. I think, I know we're all like the homeless dramatic. I think that precedent that would set would be devastating for us in the future down the line. So I could not find anything. I talked to Dan again, and there's just no way to say this is a unique circumstance and say we'd be comfortable it wouldn't set precedent.
So,
change the ordinance?
I'm going to ask that you hold all comments. I will open it up for public comment before we table it. So what you're asking that we appeal? So you're saying?
Well, I just want to make that comment. That was the reason why I asked to try to put this table to look further into this to see if there was some mechanism for relief. And there just isn't. I just don't see. Couldn't find it.
Okay. Any other board comments before I open it up for public comment?
Yeah, I thought of it many hours as well, and still have determined that we shouldn't be involved in any more appeals. So this should not be appealed any further. Okay. Again.
Any other board comments? I'm going to go ahead. Do you want to step to? I just asked you to step to the microphone and state your name and address for the record, please.
Thank you. Jeff Omatick, 249 Grange Road. I mean, this is a unique situation right here. Like I said, I'm just trying to get a place for my daughter to live. I have her insides, I didn't know this all going to happen. When it's supposed to happen this way, we do it. I took this to court because I lost. I won, like I said. I know I won, but can't you change the ordinance so nobody else can do this like I did from here on out?
That's a legitimate question we asked our solicitor. Just that one question. Based on the judge's ruling, the way he looked at it and applied our ordinance to the circumstances, is there a way that our ordinance was weak or in error that it should be amended so this doesn't happen again?
Well, I don't think the ordinance is weak in that regard, but if the board wants to consider looking at this kind of situation differently and amending the ordinance to allow for a provision, to allow for this kind of dual use on a property, I caution you to think carefully about that. So more than one primary use.
I'm advocating so that if it comes up again, another judge won't rule against our ordinance. I think we should never let this happen. But I mean, I know his circumstances is unique. But is there something in the ordinance that we could change so and the next judge looks at it, he'll see it clearly? I think he's mistaken in his is it either his reading or interpretation of the ordinance or the application because of so much testimony at the hearing.
But am I wrong? That's not what Mr. Omatick's asking. What you're asking is for us to let you go and then tighten up our ordinance so that
That's the
there
next
are.
person, that's.
Right, that's exactly what I'm asking
Yeah,
Gretchen.
but we
is
What
what-
I'm worried about, someone else doing this.
But we can't do that. Like, as much as I feel for your situation, our ordinance is what our ordinance is, which is there's one primary use on a parcel. We can't just look the other way knowing that that's what the situation that you have, and then say to everybody else in the community, we're gonna tighten this up to make sure that never happens
But
again.
that's exactly what Judge Lucas did. I mean, he read it a certain way and he reversed the zoning hearing board's decision.
He's treating a mobile home somehow differently.
Non-conforming use.
You know, he's treating the mobile home as temporary in nature, which in these kind of circumstances, it's not. But I think the evidence is clear that it's not temporary in nature. I mean, Mr. Omatick will say here today, it's not meant to be temporary. You want a place for your daughter to live, it's a home.
Correct.
Yeah, so this appeal, you have to make a decision on this appeal regardless. And if you want to make a change to somehow allow for this kind of situation, which would be a sweeping change in my opinion, that's something you
But I
consider.
don't want to allow for that.
Could you also amend the ordinance to be more clear? Of course, you can always improve an ordinance. But our ordinance, as it stands right now, you know, we have to deal with it in this particular decision.
So exactly how did he say that he considers, most people take them off the wheels if it's a mobile home. It's not a modular, it was actually on wheels, axles, and
Double wide, yes.
and they take the axles out. I mean, there's axles under originally, wasn't there?
Originally, well, I didn't get it. I'm sorry.
But I'm saying, normally you take it out of the axle and set it on block, whether the block is a permanent foundation or not. Did he basically take the position that any mobile home brought on a piece of property is temporary?
I think that's what you have to be very concerned about. Absolutely.
I'm not an attorney, so I don't know what you guys are talking about. My attorney can't make these on
Yeah, I mean, I drafted my full analysis, so you have the full analysis, but there's a big concern for this board about the implications of that decision moving forward.
I mean, we're just wasting taxpayers' money, wasting my money. I don't really want to take this. But I don't get a lot of phone calls about wasting money, taxpayer money on this. And I'm sure your phone's going to be ringing.
With all due respect, though, we can't have multiple primary uses on one parcel. And so that's really the issue. And it's not a waste of taxpayer dollars because I read through Gretchen's analysis, I also read through the judge's ruling, and I don't think that he fully understood the scenario, which is her residence is permanent. It's not, something that you're gonna put there for a couple of months and then pull out and leave, which is temporary. This is a permanent residence. We can't have multiple permanent residences on one parcel. We're opening ourselves up to a whole host of other issues.
Dan, what's the zoning on that property? Is it R4?
Or one dollar.
R1,
It's R1, right?
correct. It's a split parcel.
So I guess to finish up on my question, if the judge interpreted it that way, is that an accurate interpretation to say mobile home is not considered a permanent structure?
I disagree with the opinion and the interpretation.
No, you disagree with the judge.
A trailer, I'm sure those things call it a trailer.
Can I ask you this? Do you think a judge will overturn another judge's decision? I'm just asking.
I think,
It happens all the time on appeal.
I'm just asking.
But, all I can say to this board is you have my full analysis and the opinion. If there is no appeal, then this situation is then essentially blessed, and you have concerns about the next similar situation that comes down the pike and how to treat it.
Or assuming we didn't appeal it, and whether you subdivide or not, Dan, it's a question for you. What's the circumstance with the DEP on
on-lot septic tie-in? He says that obviously they won't do
So
something.
Mr. Omatick offered to subdivide the property, that was our original solution to the whole problem. So we went round and round with the DEP on this, and I didn't believe that they would be this rigid on it myself. I made the calls myself, talked to Tim, I'm sorry, I couldn't think of the name of the person. There were two people at DEP we talked to, but Tom Flanagan was the one. Tom's been there forever. And he referred me to another guy, and they emphatically said, unless there's a solution for the trailers that are there right now, and there's a comprehensive sewage plan for everything that's up there, they're not going to allow subdivision to occur. And in Pennsylvania, if you subdivide property, you have to have an approved planning law.
Right, now, if the circumstance where it exists today up there on his property, if we didn't appeal, obviously our end drops. Will he be tied into some existing system like on the house? And will the DEP come after him for that?
I don't know. Do you have approval on the current location for on-lot system from the Washington County Sewage Council? I mean, as long as the Sewage Council is blessed his current on-lot system.
Even for the mobile home, I have a system.
For the one you lose.
Yes.
There's no system for the other ones. They're just Wildcat, right? I mean,
There is system for them.
okay.
Each that's for all. There's only 4 left, and once they move out, I'm not moving them back.
Right.
So I'll keep, when I used to get them the next side.
That's okay, I actually we forgot to remind you, right? No worries. I think at this point, as much as we feel for your situation, and I can only speak for myself, like, we have to be cautious of the precedent that it's gonna set going forward.
I misunderstood. I thought he was just put it on the lot and was going to tap into the house system. I didn't know he had an approval. I guess I missed that.
An approval from him.
For an on-lot system.
You held the application somewhere.
So we can always withdraw the appeal. If you want, we can submit the appeal today because we have to take the vote and I still think we have to take the appeal because the issue isn't necessarily your situation, Mr. Omatick. The issue is the precedent that it sets for everybody else, which the way the ruling reads is that mobile homes or trailers are temporary in nature, which they're not. And then it opens us up to the potential of me saying, hey, my mother and father-in-law want to live in a trailer in my front yard, and even though I already have a primary residence on my lot, I could put another permanent, or in their eyes temporary, but a mobile home right in my front yard. It just...
Okay, there's a house on the Poly, the doctor.
I'm sorry.
There's a house on the Poly Road, he's a doctor. He built a big house off to the side. He did not get a subdivision. He called it a pool house. His daughter lives there. Now, how did he get away with it?
I wasn't aware of it. Yeah,
Do some homework.
Yeah.
There's a lot of them in this township.
Well, you're allowed to have accessory structures subject to the accessory structure
So if I
rules.
put a swimming pool in, I call it a pool house.
But if somebody snakes a bedroom in something,
You can't do that.
garage or something like that, I mean, it's up to the township. They have to catch them doing it.